Marshall, on behalf of the people.
David Riley on behalf of Mr. Price.
Okay, today was the date and time set for a jury trial. Witnesses here.
Your Honor, I do have two witnesses present. I attempted to speak with them Thursday and yesterday. I finally received an email back from them at 10:29 last night. So I was unable to speak with them to prepare for that,
To prepare for what?
to prepare for the jury trial to move forward.
Well, this matter's been set for jury trial for a while, so that's not a necessary excuse. And they should have been aware because they were present at the final pre-trial. Are we ready to proceed to call a jury in?
My client and I are prepared, yes.
Calling a jury. You can have a seat, sir. On the record, in the matter of the people of the state of Michigan versus Mr. Bond versus custody. Yes. Okay. Okay, Gavin Bombers, file number 23-03323 and 23-03662, council appearance.
Marshall, on behalf of the people.
Jacob Riley on behalf of Mr. Price. For one of the files.
Who's on the other one?
John Lee's on the other one.
I represent Mr. Bomfries on the retail fraud file 23-03662.
Okay, today was the date and time set for final pre-trial. Our understanding as of this morning is that Mr. Bombers is in the custody of Eaton County Jail, so he would not have been written over. Do we have witnesses here?
We have a witness as to the retail fraud, but not the domestic violence.
Okay. How do you want to proceed on that?
The people would be unable to proceed on the domestic violence, given that the victim is not present. The retail fraud, we would proceed.
Okay.
Defense would request dismissal, certainly of the domestic violence.
Okay, file number 23-03323 will be dismissed without prejudice. You can get in contact with your client and advise your client of what that means, okay?
Yes, sir.
File number ended in 03662, that's set for, did we set it for a trial yet?
Yeah, we're gonna have to reset it.
Okay.
April 30th.
April 30th at 8 a.m. You'll get in contact with your client, because I don't know how long he's gonna be in Eaton County, and you'll advise your client of the next court date.
Yes, Your Honor. Thank you.
Any additional matters for the record?
Nothing from the people.
Thank you. Okay, on the record, in the matter of the people of the state of Michigan versus China Roberts, file number 23-03624. Appearance, please.
Marshall, on behalf of the people.
John Lee on behalf of China.
Is China Roberts present?
I thought,
Sorry, Your Honor, Ms. Roberts is not currently in the court.
Okay.
I have not.
Champagne warrant. The record in the matter of the people of the state of Michigan versus Frederick. File number 23-03610. Appearance, please.
Marshall, on behalf of the people.
Assistant Public Defender John Lee on behalf of Frederick Greer.
Okay, how are you, Mr. Greer? Okay, today was the date that was set for final pretrial. Do we have witnesses here on the assault and battery?
Yes.
Okay, we're continuing to trial, or was there an offer?
Your Honor, there has been an offer, and I did discuss it with my client. However, upon further discussion with the prosecutor, it was brought to my attention that the felony charges that involved the same witness that were previously dismissed had been reissued. And so the prosecutor suggested that perhaps this file could be dealt with as part of a global resolution that would include his felony files. So rather than proceed to trial, we would ask the court if it perhaps would consider resetting this as either a pretrial or another final pretrial.
Okay, there's the same victim for the felony.
Correct.
When is the exam on that? Do we have?
I didn't see a date in my notes as it was just reissued.
Oh, okay, so he hasn't been arraigned yet?
I'm also not sure the answer to that. I saw the complaint, the new complaint was signed.
What's in warrant status?
He hasn't been arraigned on it yet at all. He
He's
doesn't even
got
have a date.
He's gotta turn himself in. You gotta go down to the jail to be arraigned on the warrant.
Yeah, I figured that.
Okay, let's see. He's gonna go be arraigned today, or go set to be arraigned today. It's 9 o'clock, so there's no reason why you shouldn't be able to get arraigned if you go down immediately. And then give me, I guess we can reset this until after, or the end of the month. He should have had an exam date by then. I'll do another final pretrial. No witnesses will be required for the next final pretrial.
So April 30th to 8th.
April 30th.
You said no witnesses would be required.
Correct. We'll get you a copy of your notice. Do you have any questions today?
No,
Record on that. On the record in the matter, people of the state of Michigan versus Amadas Clark, file number 24-00177, counsel appearance.
Marshall, on behalf of the people.
Jacob Brown on behalf of Mr. Clark.
Okay, how are you, Mr. Clark? Said there, no witnesses, is that what's going on here?
That is correct.
Okay. 30 witnesses have failed to appear. The people are moving to dismiss this case without prejudice, okay? They have the right to reissue the charge against you within the statutory time frame if they re-engage with the witnesses and they're ready to proceed, okay? Do you have any questions? We'll get you a copy of the dismissal and you'll be all set.
Thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus Gregory Brown variant. File number is 23-03656. Counsel appearance.
On behalf.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Gregory Brown Berry, who is present standing to my right.
Today was the date set for final pretrial. How are you, sir? No, thank you. Okay, the people are unable to proceed. I'm assuming they don't have necessary witnesses here. Is that accurate?
Your Honor, that is correct. As to the DV, I believe the officer would not be subpoenaed for the attempt RNO.
They do not need to appear for final pretrial, correct?
So we would move to proceed on the attempt RNO.
Okay, and move to dismiss the domestic violence.
Correct.
The domestic violence will be dismissed without prejudice. They do have the right to reissue the domestic violence against you. Do you understand that?
Yes, ma'am.
Okay, what day is the separate trial?
Next week.
This matter is up for a jury trial.
Your Honor.
Yes.
The offer prior to today was based on both charges. So when I came in today and they were unable to proceed on domestic violence, I asked for negotiations on the remaining charge. It's my understanding that Mr. Marshall is unable to negotiate today, but that's what I
We're gonna
wanted.
find a pre-trial day.
Yes.
I would need to speak with the officer on their proposed resolution.
I don't have, but we'll note it. We can convert next week to final pre-trial.
Okay.
Any questions for the court today? Any additional matters for the record?
No, Your Honor.
No, Your Honor.
You're all set. Sir. You can hang tight if you want a copy of the dismissal on the domestic violence. On the record in the matter of the people of the state of Michigan versus Shaie Fes, file number 24-00545, council appearance.
Marshall, on behalf of the people.
Assistant Public Defender Donnelly on behalf of Shawnee.
Okay, how are you, Ms. Funches?
Good morning.
Good morning. Today was the date set for a pre-trial on one count of domestic violence. Was there an offer on this?
The offer was to plead guilty as charged with no upfront jail, with no objection to a 769 status if eligible.
Your Honor, at this time, we'd like to set the matter for final pretrial and trial.
Oh, no. They sound at 8 AM in person at the court for the final pre-trial. Jury trial, May 21st. May 21st at 8 AM for a jury trial. Get you a copy of your notice to appear. Do you have any questions for the court today? Okay,
Your Honor, I have one question. What was the date of the final pretrial?
May 7th.
Second.
Okay, any additional matters for the record?
Nothing from the people.
Nothing for the record.
You're all set, ma'am. You're welcome. On the record, in the matter of the people of the state of Michigan versus Scott Elijah Juan Hatcher, file number 19-3376, appearance, please.
Bob Marshall, on behalf of the people.
Jacob Riley on behalf of Mr. Hatcher.
How are you, Mr. Hatcher?
How you doing?
I'm well, thank you. Okay, we have a pre-trial on a larceny and a PA 53 contempt. Set for hearing today. Let's see. Okay. Allegations of a violation of a no contact order. How are we proceeding today?
Can I check the call briefly to see if the officer is present on the PA-53?
No worries, I doubt that they're not here, but you can go and check.
Yeah,
Yeah.
seeing the name of the officer. I do not have those.
Okay, I don't even know that one was subpoenaed, or your office was aware of the consent for hearing?
I believe they were sent a subpoena. Whether
Okay.
they received that or not, I'm unaware of.
Okay, well, we probably need Carmen Owens here. And so I'm assuming they're gonna ask for final pretrial.
Yes.
May seventh at 8 a.m. for final pretrial, and we'll reset the PA 53 till that date. First for the jury trial. May 21st at 8 a.m. for jury trial. You have any questions today, sir? Okay, we'll get you a copy of your notice to appear. And reiterate, there's a no contact order that's been in place since 2022. You're not to have contact directly or indirectly with a Carmen Owens. You're not to cause anybody else to have contact with her on your behalf. Do you understand that? You understand that a contempt of court, which is a violation of your bond, that could result in you sitting in jail for 93 days. Also could result in you paying a fine of up to $7,500. You understand that? We'll get your copy of your notice to appear. You'll be all set, okay? Record in the matter of the people of the state of Michigan versus Cory Smith, file number 23-00421 and 23-00422. Appearances, please.
Bob Marshall, on behalf of
Some public defender on behalf of Cory Smith.
Cory Smith present.
I do not see him, Your Honor. I did speak with him yesterday. And he informed me that he was going to be here, but I do not see him. I don't believe he's on here.
Issue a bench warrant bond forfeiture. On the record, in the matter of the people of the state of Michigan. I think we did everything that's okay. Are you waiting for a case, ma'am? Oh, okay, sounds good. Well, I don't have any jury instructions for Price from the prosecution. I have the defense jury instructions.
I will get those drawn.
Representing Mr. Alejo.
That would be me.
Okay, on the record in the matter of the people of the state of Michigan versus Eduardo Alo, file number 24-00573, counsel appearance.
Jacob Riley on behalf of Mr. Alo.
Mr. Prosecutor. Who is Mr. Kamar Rai? He hasn't interpreted. I requested. It's on. He's messaging. I need your appearance on Alejo.
Bob Marshall, on behalf of the people.
Okay, today was the date that was set for a pre-trial, and this is for domestic violence. How are we proceeding?
And at this time, you would ask that this matter be set for final pre-trial and trial dates.
Was there an offer?
Yes, Your Honor, the offer was to plead guilty as charged with no upfront jail and no objection to 769 status.
May 7th for the final pretrial. May 21st for the jury trial.
Okay, Mr. Alejo, your final pretrial will be May 7th, 8 o'clock in the morning in person at the court. Jury trial, May 21st, in person at the court. Do you have any questions today?
No.
Any additional matters for the record, counsel?
Thanks, Your Honor.
No, Your Honor.
You're all set, sir. Thank you. We have an interpreter here for Rai. Interpreter. Kamar Rai, can you hear me?
Yes, hi.
Hi. I don't see an interpreter yet, so hang tight. We'll see if they appear later, okay?
Okay.
On the record in the matter of the people of the state of Michigan versus Alexia Alanis, file number 23-03751. Appearance, please.
Bob Marshall, on behalf of the people.
Assistant Public Defender John Lee on behalf of Alexia Alanis.
Is Alexia Alanis present?
I do not see her present in the courtroom.
Have you made contact with Alexia Alanis?
I have. I take that back. I spoke with her grandmother. I have not spoken with Miss Alanis yet.
It's your bench warrant. On the record in the matter of the people of the state of Michigan versus Joseph Robert Allen Boss, file number 23-03399 and 24-00062. Council appearance.
Bob Marshall, on behalf of the people.
Assistant Public Defender John Lee on behalf of Joseph Ellenboss.
Okay, file number ending in 0062. We reset that matter so that he can consider the offer as, let's see. File number 3399, looks like offer was extended for him to plead guilty in the malicious destruction of, or to the malicious destruction of property, and the people would dismiss the file number of 24-00062, defendant to pay restitution $846.54. Has your client had sufficient time to consider that offer?
Yes, he has, Your Honor. And in fact, counter offered to the prosecutor to just tweak that offer a little bit. Mr. Marshall, filling in, didn't want to make the final call on that. So what we're proposing is perhaps a 1 week or even a 2 week adjournment so that we can get with Ms. Page and hammer out a final resolution.
Okay,
Yeah, Your Honor, I would note that that was a gun charge, so most of those conversations, anything with gun now would have to go through John DeWitt, so that's part of that process, will be part of that process as well.
sounds good.
And do April 16th at 10.
Everybody's have to go for April 16th at 10 a.m. No problem. Do you have any questions for the court? Any additional matters for the record, counsel?
Oh, yeah, sorry.
Nothing for the defense. Your Honor.
Thank you. Okay, on the record in the matter of Tashi Odo Brown, 4-00574. Is Natasha Odo Brown present?
I do not see Ms. Odo Brown in the courtroom, Your Honor.
Have you been in contact with Odo Brown?
No, I have not been able to establish contact.
Excellent. On the record in the matter of the people of the state of Michigan versus Marquez Robinson, file number 24-00575. Appearance, please.
Marshall, on behalf of the people.
You have an attorney? You can stand up. You not have an attorney? Did you request court appointed counsel?
Yeah, they said it qualified.
Okay, are you gonna hire an attorney?
No.
Okay, you're gonna represent yourself in this matter?
Yeah.
Okay, you need to go get fingerprinted.
Okay.
You understand that you're being charged here with the domestic violence. It's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines, correct? And you understand your right to be represented by counsel, even though you've been denied representation, correct? Okay. And you're going to attempt to represent yourself?
Yeah.
Okay. Let's set this matter for a final pretrial. Was there an offer?
The offer was to plead guilty as charged, no upfront jail, and no objection to 769.
You understand what that offer means? Okay, they're saying if you plead guilty to the charge, they're not going to object to sentencing under the special statute that requires if you do a term of probation, if you're eligible, and if you complete that term of probation successfully under 769.48, then your record of this conviction will become non-public.
Okay.
Okay, so you'll have time to think about that because I'm gonna set it for final pretrial. That'll require the alleged victim to appear in person. You need to appear in person as well, okay?
May 7th at 8 a.m.
May 7th at 8 a.m. We'll also give you a jury trial date at this time.
May 21st at 8.
May 21st, also at 8 o'clock in the morning. We'll get you a copy of your notice to appear. You need to go downstairs before you leave to be fingerprinted, okay?
Okay.
You have any questions for the court?
No.
Okay, any additional matters for the record, counsel?
No, Your Honor.
We will get you downstairs in just a moment, okay? On On the record in the matter, the people of the state of Michigan versus Dael Bell, file number 24-00599. Council appearance.
Bob Marshall on behalf of the people.
Okay, and Bell is present via Zoom. Does Bell have an attorney?
I believe it's Mr. Rowley.
I don't even. Well, I don't see him on the docket, so. Your appearance on the matter versus Dael Bell.
Jacob Rai on behalf of Ms. Bell.
Okay, Ms. Bell, can you hear us?
Yes, ma'am.
Okay, today was the date that was set for a pre-trial on a domestic violence. Was there an offer on this?
Yes, again, Your Honor, was the plead guilty as charged, no upfront jail, no objection to 769 status if eligible.
How does your client want to proceed?
At this time, we would ask that this matter be set for final pretrial and trial dates.
May 7th, 8 AM for final pre-trial in person at the court, okay? Ms. Bell,
Yes, ma'am. May 21st for the jury trial.
your jury trial will be May 21st, 8 o'clock in the morning in person at the court. We need you to be fingerprinted. So you need to come down this week to get your fingerprints taken care of, okay?
Okay.
If you have any questions at the court,
No, ma'am.
any additional matters for the record.
Nothing from the people.
Nothing from the defense, Your Honor.
We'll see you in person on May 7th, and don't forget to have your fingerprints this week taken care of, okay?
Okay. And you said May 7th, not May 21st?
You have May 7th and May 21st,
Okay,
2 dates, okay. Thank you,
thank you.
you're welcome. Is there an Elias Griffin here? On the record in the matter, the people of the city of Lansing versus Chanty Mendenhall, file number 24-00474. Mr. Lee here?
Yes,
Okay, this is your client. I'll take your appearance on the record.
Assistant Public Defender John Lee on behalf of Chanty Mendenhall.
Thank you. Mr. Mendenhall, what's your phone number?
517-455-8252.
You have that number, Mr. Lee?
Check that right now. Four five five 8565
8252.
8252.
That's what he said. That's what we have in our file. Okay, Mr. Mendenhall, you were present on March 8th before the magistrate on a failure to stop after property damage accident. And you entered a plea of not guilty. You were advised of your rights. You requested an attorney. That is your attorney. Have you ever met with him? You didn't appear to court on the date you were supposed to appear, which was yesterday. Did you get your dates mixed up?
No, I didn't get the date mixed up. I don't even, I was just dealing with my daughter yesterday and it just really slipped my mind that I had court.
Okay.
So then I remembered last night, I'm like, oh my God. So then I came up with.
Okay, sounds good. You have two options. Your attorney can see if a city attorney will come upstairs and try to work this out today, since you're here in the building. Or you could come back on April 16th at 8:30 in the morning.
Like the matter of the whole thing.
The case is pending. You gotta resolve it. So your court date was here yesterday. He doesn't work for the city. He works for the state. So he can't negotiate a plea deal on this or talk about resolution.
16th.
You said what?
What was the other
You're
option?
set for April 16th at 8:30. That's what they said it for.
That's the wrong day. It's Tuesday.
Okay, they said it for the wrong date anyways. There you go. Should be April 15th
We can do it at 10.
at 10 o'clock in the morning, okay? April 15th, 10 o'clock will be your next court date. You'll talk to your attorney before then. He can contact the city and find out if there's an offer and you can discuss it with them before court. And then we'll see you April 15th at 10 o'clock in the morning. We're gonna get you a copy of your notice to appear, okay? You were noticed when you were out there. Making sure if they did, I'd rip it up for you. Okay, you have a seat, we'll get you your notice. Your bond will continue at 100 personal recognizance.
Thank
You turn the fan on when you get a chance.
What was it?
You turn the fan on when you get a chance.
Yeah.
Turn it on medium. We're supposed to put Jerry Keane on.
He's downstairs.
She's downstairs. Who's representing Jerry Keane?
I am, Your Honor.
Okay. Be brought up.
Okay.
Anybody here for an Elias Griffin?
That is my client, Your Honor. Not seen.
Good bench warrant. Only other matter I have is Keane and then Razai. Is that accurate?
That's what I should.
Oh,
Yes, Your Honor, I did have one client show up late, Mr. Cory Smith, who was attempting to appear via Zoom, was unsuccessful, and came to make an in-person appearance.
on the record in the matter of the people of the state of Michigan versus Cory Smith, file number 23-00422 and 421, council appearance.
Bob Marsh on behalf of the people.
Assistant Public Defender John Lee on behalf of Cory Smith.
One file, let's see where that is. Okay, today was the date that was set for a pre-trial for Mr. Smith. I have 2 dog license vaccinations. How are we proceeding?
Your Honor, at this time, Mr. Smith is seeking an adjournment to get more time to get the dogs licensed. Current status is that one dog, Kobe, is vaccinated. The other dog, Moana, will be vaccinated as soon as possible, probably 2 to 3 weeks out. And then he will get them both licensed immediately thereafter.
You gave him a year to do that.
I didn't have,
Excuse me?
I didn't have the funds. I wasn't expecting, I didn't know how much it was gonna cost to get them seen. I didn't know how much. I just recently got a new dog and I haven't had him that long. My dog, I didn't realize the tags or she needed up-to-date shots. So the dog I just have, I can get licensed immediately, but my dog, I didn't have the money to pay the vet fee and the license fee. So that's
Since
why-
last May,
No, I didn't.
you don't work?
I do work. I have 3 daughters and I'm just barely afloat and it was really.
You also have 2 dogs.
I do,
Dogs are additional expenses that you took on.
yes.
You gotta feed them,
I do.
you gotta pay their vet bills, you gotta get them licensed and vaccinated.
I understand.
So you can't come in here and cry broke when you decided to have dogs.
Right.
And we gave you a year, you never came back to court. Because you were supposed to, we adjourned this back on May 1st, 2023, so you can get the dogs licensed. You had a court date of June 12th. You never appeared. So how
That
do we
court
know?
date I forgot about. I didn't even.
That wasn't the first time you forgot about it, because April 17th, when you were arraigned on the previous bridge warrant, you said it slipped your mind. So it's the second time it slipped your mind. But you still have the dogs, and looking at the dogs should be a reminder that you have a court date about the dogs, no?
Right.
You have an appointment to get, they're already vaccinated?
One of my dogs, the other one is, I was waiting for 3 weeks to get into a vet. So one of them,
You have an appointment already?
no, I don't.
Why are you saying you're waiting for 3 weeks to get into the vet?
Because every place I've called was 3 weeks and I was just gonna pay the walking fee to go in and Mason Patterson's. I was just gonna pay the $120 to go in that day.
Okay, I'll get you a new court date. I didn't have the other file for some reason.
Um,
3 weeks? Yes, 3 weeks.
do April 30th at 10.
April 30th at 10 o'clock. Does your attorney have your number?
Yes.
Do you have any questions for the court today?
No, I don't.
We'll get you a copy of your notice to appear. We'll see you on April 30th.
Thank you.
You're welcome. Hello, interpreter. Do we have an interpreter?
No.
Oh, okay. What are they, who's waiting for something?
I'm waiting for Mr. Keane to be brought up.
Okay. Are you waiting for something?
No, our prosecutors.
Oh, okay. I didn't know you joined the prosecutor's office.
As of yesterday.
Oh, okay.
Jeff is also one of the new prosecutors
Oh,
who will be
okay.
joining me on the trial.
Very good. Okay. You know who the gentleman in the back is with the blue thing? I asked if there was an interpreter. He says 0 thanks. Are you the interpreter? Did you hear me ask if there was an interpreter here?
No, actually, I was waiting for him. He asked me to just sit and get a film.
Yeah, but I just said like 2 seconds ago, is there an interpreter here? Is anybody waiting for something? I knew you had a blue thing, but you didn't respond. Are you, what language do you speak?
I'm speaking,
You speak what?
this one is Farsi.
Farsi? Okay, so you're here for Razai. Who's representing her?
I am.
Okay, so we'll handle this and then you can meet with him and the interpreter.
Very fine.
Okay, on the record in the matters of the people of the state of Michigan versus Jerry Keane, file number 23-03585, council appearance.
Marshall, on behalf of the people.
Assistant Public Defender John Lee on behalf of Jerry Keane.
Okay, Mr. Keane, I have one file, but I also have a PA 53 bond violation for domestic violence, and the bond violation alleges that you violated the terms of your bond, not to use illegal controlled substance and not to have contact directly or indirectly with a Deborah Rulison. And so this matter is scheduled for pretrial today. How are we proceeding on the domestic violence?
This time, we'd like to set the domestic violence for a final pretrial and trial.
May 14th at 8 a.m.
May 14th at 8 a.m. for the domestic violence. Final pretrial, and we're going to set the PA 53 for the same date.
Jury trial, June 18th.
You said June 18th. June 18th at 8 AM.
Sorry, Your Honor, 18th or 14th?
18th
18th,
for the trial.
okay,
The final pretrial, May 14th.
okay.
Any questions?
Your Honor, my client would request bond. He's been incarcerated for how long? About 30 days.
Bond motion is denied. Any other requests for today?
Nothing else, Your Honor.
No, Your Honor.
Thank you. Okay, you take him down. We gotta move on. We have jury trial. I'll put you on Zoom with the interpreter to talk with your client privately.
Thank you, Your Honor.
The defendant just told.
Can you go get his attorney real quick? Mr. Lee, I need to go back on the record on Keane.
Very well, Your Honor. I'm on my way.
Thank you. Did I give you the other Smith file?
Yeah.
Oh. Okay. April 30th, is that it? Okay, back on the record in the matter of the people of the state of Michigan versus Jerry Key. Mr. Keane, it's come to my attention that both on your way in and out of the courtroom that you had communication with the victim.
So I love it. That's my wife.
Do you understand what a no contact order means?
I'm not supposed to have contact with her, yes.
Yeah, that means you can't say anything to her.
Oh, I didn't know if it speak.
Oh, you don't know what no contact means?
I thought there was no physical contact as far as,
Who said physical contact?
that's, oh, I didn't really understand what it meant. then.
You got a copy of your bond?
No, I don't, Your Honor.
Okay, you also have a bond violation for having unauthorized communication with the alleged victim. Is that correct?
Yes, I do, Your Honor.
Okay, let me make this extremely clear for you. You're not to have communication directly or indirectly with the alleged victim, Deborah Woolison. You can't send a smoke signal, a text message, write a piece of paper, no communication of any kind. You can't wink at her, stick your tongue out, put your middle finger up. 0 things can be communicated. Do you understand? If she's sitting next to you, you look the opposite way. You understand that? You have pending charges for domestic violence, and then now a pending contempt of court for a bond violation, and I'm going to add a second contempt of court, because right after I denied your bond, you went out there and you said something again, and I don't think you're that stupid. You know exactly what no contact means. No one said no physical contact. Nobody told you you couldn't touch her. We say you couldn't be within a certain amount of feet of her. You can't have communication directly or indirectly. You can come in here and play dumb if you want to. It's gonna land you in jail for 93 days. Do you understand that? That's why your bond was denied. That and the allegation that you're using illegal drugs while out on bond. Bet you didn't understand that either, that part of your bond?
I didn't understand that.
Oh, okay, thank you. I'm gonna, again, reiterate, there's not to be any communication directly or indirectly between you and the alleged victim. I'll leave it to the prosecutor's office for them to pull your records and find out what's going on while you're sitting in jail. Do you understand that? Do you have any questions to help you further understand the bond conditions?
No. I got sentenced to 93 more days though.
No, you're facing additional 93 days. Do you understand that?
Yes, I did.
Do you have any other questions?
No.
You can be excused. Hey, Mr. Stevens.
Hi, Judge. How
See,
are
you all are hiring away around here.
What's that?
So you got some new people on the team.
Yes,
Congratulations to you.
yes. It sounds like one of them is gonna jump into the fray today.
That's how it's supposed to be, right?
I like it.
Jump in and get your feet wet immediately.
That's right. Just you're not allowed to bark at them, okay?
Well, I'm not promising that.
Come on, get this camera away.
That's how you learn.
I guess this is day 2. So I guess you can bark at them.
That's how you learn. No, yeah, but what we're not gonna do is walk out of here and say, "I love you, baby," to the victim.
Yeah, well.
And from what I was told, that's not
Every
what
day
he
is
said.
interesting.
Well, no, it was 2 things, my understanding.
Oh, okay.
My understanding is when your colleague heard something and then my court officer heard something too.
Okay.
Yes. Judge is a Patriots fan, so, just keep that in mind.
He's doing good, he's got on blue.
What's that?
He's doing good, he's got on blue.
I mean, so let's just keep that in mind, so we're not,
Just gonna end up with JJ.
digging out of the hole right at the beginning.
Hard time. Okay. We're just waiting on one more retry, I think.
I don't.
Just for me.
We didn't have the file, or Marquez still had it.
What do I need to do?
That one is the charge of domestic violence. just nine. And then the other one, I think that was set, let's see what the date. I'm still trying to figure out that plan.
I signed an ollie.
Yeah. We're scheduled for another, so the final pretrial was converted, you put it on the ROA. the other one.
Convert to next week to find, oh. That's what it was.
So she's from mistaken.
April 9th. So wait, they nollied the felony already, no?
So that was what the amended complaint, we and Marquez were talking about it earlier, yeah.
Is that the one I see the email about again today?
Yes, yeah.
This has been like a, we need to get Mr. Stevens while he's here. Wait, what is the issue with it now?
So in your notes, it said that it was supposed to be amended to an attempted RNO. But
That's what
she
they said.
dismissed it, added account 3 of attempted RNO. So Marquita was like, with that wording, we're gonna need a nollie. And I'm like, and she was like, unless she changes it, it amends the count 1 to attempted. And then leaves the domestic violence and everything else.
Yeah, if she's amending it, we need a new complaint.
Right. But
If
she
she's
just
dismissing
she
it,
did it a different way. She put dismiss, like it's in there. She put dismiss count 1 and then added a count 3. And then count 2. is
yeah,
still there.
that's different.
Yeah. So Marquita was like, unless she has to either provide us a new one or a nollie, but she sent her email.
Oh, sounds like a class. I know, who wants to file? You were running to. I'll just put it over there for now. There's that. I don't know what they want me to do with this. They just gave it to me. But it looks like it's a default. Taylor, Christopher Taylor.
What's the
Case 23L2789041. Really
show
want me
up
to
for
do?
something?
Yeah, it just says
There's
balance
nothing
under
in the-
86.
In JIS since
Did he have,
December 5th.
yeah, what do you want me to do?
I can ask them. Who did it? Who's?
Zach, I think. Zach, is that Zach? Fire plate. Post office return mail not deliverable. I mean, is he putting this note because he wants us to set it for show cause? Is that what he wants? Because he didn't tell us.
I don't even think we would have done that. The
Set
first
it for
one,
show
they
cause.
always
How
do.
about that? Because it looks like he's gotten this ticket a long time ago.
Oh.
Not that we have an address to send him a show cause on.
Um,
We'll figure something out, I guess.
We'll just set it.
Yeah. I'm hungry.
Yeah, yeah.
I don't remember that being what we decided in the meeting. I agree, need this.
Please.
Hello?
Bra. Only your man.
Oh.
Parts like it, but.
And so I couldn't tell you, you have to tell me if you need them, I couldn't tell you.
Let me see.
Okay, on the record. In the matter of the people of the state of Michigan versus Kamar Rai, file number 23-01773. Council appearance.
Okay, are we doing that before he interprets? Okay, Bob Marshall on behalf of the people.
Assistant Public Defender John Lee on behalf of Kamar Rai.
Interpreter needs to come up. Please state your name for the record.
My name is Amin Zindi, Amin. Last name is Zindi, Zindi.
Okay, and can you raise your right hand? Do you solemnly swear or affirm you'll interpret in the matter now before the court completely and accurately and not divulge confidential communication to help you God?
Yes, I do.
Can you tell the Ms. Rai she needs to start her video? Okay.
خانم رضایی من در برابر محکمه هستم. قاضی از من تعهد گرفته است که فقط حقیقت را برای شما بگویم.
Okay. Today's the date set for pre-trial.
امروز روزی است که هنوز محکمه شروع نشده است بلکه این پیش مقدمه محکمه است.
Tell her I need to see her face.
خانم قاضی می‌خواهد که چهره شما را ببیند. اگر می‌توانید چهره خود را به او نشان بدهید.
Count 1, assault or assault and battery.
در اینجا پرونده ای هستش به عنوان بدرفتاری شما با دیگران.
Count 2, breaking and entering illegal without owner's permission.
مرحله دوم این است که شما بدون اجازه داخل خانه یک نفر شدید که او اجازه رو به شما نداده، مالک خانه به شما اجازه داخل شدن به خانه او را نداده است.
Was there an offer?
Yes, Your Honor, it looks like the offer was to plead to assault and battery with a Gilbert and all front jail.
اون طرفی که هستش اونم همینو میگن که جدا حکم برای شما هست که شما در اونجا با کسی بدرفتاری و دخل کردیم و دوم اینکه بدون اجازه به داخل اون خانه رفتید.
Do you discuss that with your client?
I did not discuss that with my client. But based on my discussions with my client, it would be difficult for me to believe she would be interested in that, but I will obviously mention that to her before our next date. She wants to set it for a final pre-trial.
Well, you gotta mention it to her now because we had to bring an interpreter in here.
Can you just tell her what the assault and battery is? Yes. Thank you. You want me to take another breakout room?
Well, no, you're gonna talk to her on your own time with the interpreter here because we're gonna start a jury. We have a jury downstairs.
Okay.
But she needs to have her questions answered about that now, I would imagine.
Sure.
Are you gonna interpret that?
در یک بار دیگر ما شما رو به اتاق دیگر میبریم. اینا یک پیشنهادایی دادن که وکیل میخواد شخصا با شما گپ بزنم که ما باز به اتاق دیگر میرویم. شما خواهید بود جناب وکیلتان بود و من به حیث مترجم در خدمت شما خواهم بود.
Fix your final pre-trial date.
May 14th at 8 AM.
May 14th, 8 AM in person.
شما خواسته بودید اگه میخواین در یک جای نوشته کنید که روز 14 برج 5 می 14 ساعت 8 بجه صبح شما خودتون باید در اینجا حاضر باشید. این را یادتان باشد 14 برج 5 در ساعت 8 صبح شما باید در اینجا حاضر باشید.
Jury trial,
June 18th at 8 AM.
June 18th at 8 AM.
اگر این محکمه نتیجه نگرفت محکمه دوم خواهد بود که در برج جون است. در برج ششم هستش، در 18 برج 6 است.
You must appear in person.
و باید شما شخصا در این محکمه حاضر بشوید.
درسته. What time?
16 September.
June 16, what time? 8?
June 18th, 8 AM.
8 صبح 8 بجه.
She needs to come in and get her fingerprints done.
و باید شما به اینجا بیایید و در اینجا شما انگشت نگاری بشوید.
When is she going to come do that?
چه وقت شما وقت دارید که بیایید و از انگشت شما انگشت نگاری بکنید؟
نه.
امروز میایم. در کجا داد؟
Where? کجا بیایم؟ The police station بیایم؟
But I supposed to go for the fingerprint, Your
She
Honor.
comes to a city hall and she'll go to the police department.
در همین در داخل محکمه که در اینجا هستش، نام این سیتی هال از نام این ساختمان بیلدینگ، یک جایی است به نام پلیس دپارتمنت. در اونجا شما میره و میگویید که من باید در اینجا فینگرپرینت یا انگشت نگاری بشوم.
Okay.
When are you coming to do that? Today or tomorrow?
آیا امروز یا صبح میتوان شما بیایید؟ کدام روز میخواهید بیایید؟
Today?
امروز میایید؟
بله.
بعد از ظهر میایید؟ کی میایید؟ مثلا 1 بجه 2 بجه یا پیش از اون میایید؟
2
I can show up today between probably 1 or 2 p.m.
Okay. I'll note that in the file. And does she have any questions for the court today?
آیا شما سوالی از خانم قاضی دارید امروز؟
نه سوال خونه دارم در مجه پنجه من نگرفته بود.
گرفته بودن از شما؟ شما گفتید از شما گرفته بودم اونجا؟
یادم نیست اونجا نگرفته بود. گرفته بود یا نه یادم نیست.
I believe I did this fingerprint before, as much as I remember. Do you have it in your report, Your Honor?
We do not.
ما این را نداریم. این پنجه شما را ما نداریم.
Okay.
Any other questions?
آیا سوال دیگری داری شما؟
نه تشکر.
No, thank you.
Okay, hang tight so you can speak privately with your counsel about the offer, okay?
ما بار دیگر ما با اون اتاق می رویم و باز یک بار دیگه در رابطه با همین موضوع با وکیلتان شخصا گپ میزنیم.
الان آله
5 دقیقه 2 دقیقه دیگه ما با اتاق دیگر می رویم. بله.
Okay.
Off the record on that matter. Thank you. On the record in the matter of the people of the state of Michigan versus Anthony Price. Counsel appearance.
Bob Marshall on behalf of the people.
Jeffrey Dael Bell on behalf of the people, Your Honor.
Have your appearance for the record, please.
Jacob Riley on behalf of Mr. Price.
Okay, Mr. Price is present. Mr. Price, I recognize that you were not seated in the courtroom, but it's not customary to wear a hat in a building, period, not just when you're in the courtroom. Someone taught you that? I can't hear your response. Okay. But nonetheless, we are ready, the jury is here, we're ready to call them up. I did forward jury instructions. Did you all receive them?
Yes.
Yes,
Okay.
Your Honor.
Do we need to make any corrections to the drafts that I sent?
Defense says no. Your Honor.
None from the people.
Okay, any preliminary matters before we call the jury up?
None from the people.
Okay, you can bring the jury up.
The other party didn't show up in here.
Okay, got it. Okay, let me get some people in the jury box. Everett Rawlings, seat number 1, you'll walk around this way. Seat number 2, Aaron Cleveland. Number 3, Anissa Uberoff. You related to an LPD officer, Uberoff?
Yes,
In what capacity?
he's my husband's cousin.
Oh, okay, you can go in seat number 3. Mitchell Gum, number 4. Kyle Dowling, 5. Annette Spare, 6. And number 7 will be Sylvia Wilcox. That should provide enough space for seats now. Oh, yep, the seat on the corner there. Okay, everyone else can be seated.
It's hard for me to sit. I got a sciatic nerve issue that I'm dealing with.
Okay.
I gotta do it in like a 10-minute increment.
No problem. What is your name, ma'am?
Heather Warner.
Okay, so you want to
Try to sit for as long as I.
yeah, and stand up and be seated as often as necessary, okay? Okay, good morning still. Ladies and gentlemen of the jury, I am going to do a presentation for you here. Let me see what's going on with my share screen. Okay, ladies and gentlemen, I am Judge Kristen B. Simmons, and it is my pleasure and privilege to welcome you to the 54A District Court here in Ingham County, City of Lansing. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair, impartial jury to hear this case. During jury selection, the lawyers and I will ask questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may be otherwise qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of two ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask you to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer the questions truthfully, fully, and honestly. So all the jurors, even in the jury gallery, must stand. Raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? If you do so, just say I do. I do. Thank you. You can be seated. Let me introduce members of my court staff. To my right is my court recorder and judicial assistant, Addie Nash. Over to my left is Mr. Remington Whitman. He's my court officer. This is a criminal case involving charges of assault and battery, 2 counts, which I will explain more fully later. This charge has been made against the defendant, whose name is Anthony Price, the defendant's attorney, Mr. Jacob Raleigh. Mr. Raleigh, please list any witnesses you anticipate calling at this trial.
Your Honor, the defense does not anticipate calling witnesses.
Thank you. Okay, there we have prosecuting attorneys here. One, the lead prosecuting attorney on this matter is Mr. Robert Marshall, and then he has a second chair. I will allow them both to introduce themselves and list any witnesses that they anticipate calling at this trial.
Good morning, Your Honor. My name is Jeffrey Bell. I'm here appearing on behalf of the people. In this trial, we're anticipating to call Officer Donovan Moore, Nathan Harris, and Deonta Kinnebro.
My name is Robert Marshall. I'm an assistant prosecuting attorney at Keane County as well.
Does anyone in the jury box or anyone hoping to be in the jury box know the defendant or any of the lawyers or the witnesses' name? If you do, just raise your hand. Yes, ma'am.
The name sounds familiar, but I would actually have to like put a face to the name.
Which name?
The Harris.
What's the last name Harris? Okay. You don't know why you would know him? Just that he looks familiar?
Maybe East Lake, Michigan.
Oh, could be kidding.
I'm sorry.
Okay, so you do know him?
I do.
Okay.
Wow.
Well, I was gonna ask when she talked about the sciatic nerve, well, let's not get into conversation now, but I was gonna ask when she talked about her sciatic nerve, any objection to her being excused, but now the court has more than a cause to excuse her as a potential witness. Any objection to that?
No, Your Honor. No objection.
Thank you, Ms. Heather Warner, for your service today. You may be excused.
Do I wait or do I leave now?
Ms. Snealing, how do you want her to? Anyone else know any of the people named? Or any of the attorneys named to me or the defendant? Okay. We think that this trial will last one day. When we say one day, we mean we'll finish today, not that it'll take 24 hours. If you believe the length of trial will be a real hardship for you, please let us know now by raising your right hand. Okay. Some of you may have health problems that will prevent you from serving on a jury. For example, does anyone have medical problems that makes you unable to sit for 2 or 3 hours at a time? Or does anyone have an issue with sight or hearing? You can raise your hand if any of those things apply to you.
I have hearing aids.
Okay, can you hear me clearly?
Yep.
Okay. Anybody else have any issues? Yes, sir?
Well, I'm recovering from a herniated disc, so I might have to stand after an hour or two.
Okay, yep, we won't be sitting for longer than an hour because that's a long time. And so we'll take breaks as necessary, and you all will be excused to the jury room if you're chosen to be on the jury, okay?
Sure.
Thank you. And then you can all obviously feel free to stand whenever you need, okay? Okay, this is a criminal case. The paper used to charge the defendant with a crime is called a complaint. The complaint in this case charges the defendant, Anthony Price, as follows. On or about April 13th, 2023, at the area of 416 West Genesee Street, City of Lansing, Ingham County, State of Michigan, the defendant allegedly, contrary to law, committed the act in count 1 of assault or assault and battery, and that he did make an assault or assault and battery upon the following person: Nathan Harris, contrary to Michigan Compile Law 750.81. Count 2 alleges that on the same date and time that he did allegedly make an assault or assault and battery upon a Tianta Kennebrew, again, contrary to Michigan Compile Law 750.81. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I read is not evidence. A complaint is read in every criminal case so that the defendant and the jury can hear the charges. You must not think that it is evidence of that he is guilty or of his guilt, or that he must be guilty because he was charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that Mr. Anthony Price is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecution must prove each element beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is an honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considerate examination of the facts and circumstances of this case. And now we will continue with the voir dire, and we'll start with the prosecution.
Thank you.
You're welcome.
So I'm gonna stand here so everybody can see and hear me clearly. Can everybody hear me?
Yes.
All right. My name is Jeffrey Bilbey. I'm a prosecutor here in Ingham County. And this is the phase of a jury trial where the goal is essentially oriented in finding out information about you so that we could have a jury that is both fair and impartial to this defendant who is sitting here today. So that is the goal. We're not trying to pry into your personal lives or your preferences. What we want is a jury that is fair to this defendant. Everybody agree?
Yes.
So let's talk a little bit about intent. You've heard the charges here today. The defendant is charged with 2 counts of assault and battery. You can refer intent by what someone does, what they do afterwards, and the way they do it. Everybody agree with that?
Yes.
So for instance, I'm here talking to you and I dropped a pen, right? Was that in? Do you see how I dropped it? And then let's see. Can you refer intent by those 2 actions? So if I took this pen and I swung at you, did I intend to do that?
Yes.
Okay. So you can see intent can be referred by actions, by what you do afterwards, or by how someone does something. Everybody agree with that?
Yes.
All right. Personally, I'm a big fan of CSI shows, right? I know some of you may be into that as well. Who here says we need forensic science evidence to prove this case beyond a reasonable doubt? Who here says we need to bring lab technicians with out of the world science to prove that an assault and battery occurred to the two victims. All right, that's good. That's good. It's a great jury. So we don't need to do that. And we'll go into elements on that, okay? Again, the people carry the burden of proof. I carry the burden of proof. Everybody agree with that? And that burden is to prove that this defendant assaulted two people, and he did so beyond a reasonable doubt. Not all doubt, not every doubt, beyond a reasonable doubt. You heard the judge here today saying reasonable doubt is a doubt that is made of reason and common sense. Everybody agree with that? Yes. What does that mean? It means you could use your everyday experiences. You could use your common sense and reason to judge whether this defendant is guilty beyond a reasonable doubt. Everybody agree? Yes. So by way of example, say you're coming in here to court today, and as you're getting close to the city, you see some clouds out in the distance. You come in here, you do your jury duty, and you finish, and you go outside, the ground is wet. It is reasonable to think it rained, is that correct? Yes. It's not reasonable to say a fire truck pulled over and sprayed water all over. Does that make sense? Yes. All right, so that is not reasonable. That's what beyond a reasonable doubt means, and the judge will instruct you on that. Okay, but that's just my example. Everybody agree? Yes. There will be a witness police officer in this case. Everybody agree that you cannot give more weight to the police officer's testimony than you can give a lay witness. Everybody agree with that? Yes. So just because someone is a police officer, it does not mean that testimony is way more credible than if he was not. Everybody agree? Yes. Okay. Does anyone have had any, apart from Miss Ubera? Ubera, sorry about that. You have a relative who's a police officer? Do you think maybe because of your relationship with, is it a man or a woman? Okay. And how are you related to him?
My husband's cousin.
Okay.
She has to speak up.
Will you speak up a little bit? We're recording.
My husband's cousin.
Okay. Do you think because of that relationship, you would be more favorable to his testimony, or it may make you somehow biased in this case?
No.
Okay. You think you could be fair and impartial?
Yes.
And your relationship with Uberoth does not necessarily affect the outcome of this case, is that correct?
Right.
Okay. Has anybody had an encounter with a police officer that either made you more negative or way more positive towards police officers? No? All right. So there's no issue as far as police officers are concerned, is that correct? Yes. Okay. Does anyone here have a religious objection to sitting in a jury? Like, by way of example, let's say you think only God can judge people and it's not your place to judge. No? Okay. So nobody has any religion, or not necessarily religion, it could be a personal preference that you just wish you would not be the one to render judgment. All right. Everybody agree that we don't have to prove motive in this case? Everybody agree? That is not part of the element. We don't have to prove why this defendant did what he did. Everybody agree with that? Yes. Okay. People do things for all sorts of reasons. We don't have to prove he had motive to do that or he did not have motive. Everybody agree? Yes. Okay. Who here says, I need more than one witness to prove this case beyond a reasonable doubt? Who here says I need 5 witnesses or 8? I need more than one. All right, good. Who here says, because this is an assault and battery case, I need injury, that someone has to have a broken nose or blood or anything like that? Who here says for an assault and battery to occur, there has to be an injury? All right, good, very good jury. I think that, and I'm saying this because it's come up too. I know I speak with a little bit of an accent. Anybody is having difficulty understanding me? Everybody can hear and understand everything I'm saying just fine?
Yes.
All right, thank you. Has anybody been a victim of either domestic battery or assault and battery that you think somehow it may affect your ability to be fair and impartial in this case? Yes, ma'am, what's your name? Okay, have you been a victim of assault and battery?
Assault,
Okay,
domestic assault.
and when was this? Okay, 15 years. And who did that involve? Was that with someone you knew?
Yeah, boyfriend.
A boyfriend? Okay. And do you think that incident from 15 years ago may somehow make you unfair or impartial towards this defendant here today?
Kind of.
Kind of? In what way? Could you explain?
It's pretty traumatizing.
Okay.
Okay, let me stop you there. What is her last name?
Golden?
Golden?
Yes.
Okay, we're gonna put a pin in that because I need you to focus on who's on the jury box right now.
Anybody else? Especially people in the jury box? All right, thank you. Thank you, Anna. That's all the questions I have.
Thank you, Mr. Rowley.
Morning, everyone. Thank you for being here. I don't know if any of you have ever been on trial, but I can tell you it's not a lot of fun. It brings up a lot of fears. And as an attorney, one of my biggest fears is that jurors are going to hear all the evidence and go back to deliberate. They're going to have a reasonable doubt, but they're going to ignore it and say, I just want this to be over with. I'm just going to feel guilty.
Can you speak up a little louder, please?
Can all of you promise me that if you do have a doubt, a reasonable doubt, that my client is guilty, you will find him not guilty? That's the law tells me.
Yes.
Does anyone have any, I guess, any questions or any thoughts about what reasonable doubt means in a criminal case? Of course, you've heard that my client is facing some pretty serious charges. Does anyone believe that if a person is charged with a crime, that alone means they're more likely than not guilty? Anybody believe that if a person goes to trial, rather than settling their case some other way, that makes them more likely to be guilty? Does anyone remember my client's name? Very good. No, I always ask that question, and people never remember my client's name. That's okay, because I think I'm gonna get to know him a lot during this trial. One thing I want to mention, the law tells us that we have a right, if ourselves or if someone else is threatened, we have a right to act in our own defense or the defense of another. Does anyone disagree with that? Does anyone believe that the use of force is never justified? Imagine a situation where you might have to use force to defend yourself or someone you care about. Have any of you ever been in that situation? You can imagine. I want to just ask you to promise me, and I know this has already been discussed by the judge and the prosecutor, but just want to make sure you understand how important it is to me and my client. We really pay attention to all the evidence, everything that is said in court today. We take it all into account later when it's time to deliberate. If that reasonable doubt is present in your mind, don't ignore it. Think very carefully about whether you believe my client is guilty or not guilty. Okay. No further questions, Your Honor.
Thank you. All right, prosecution challenges for cause.
None, Your Honor.
Thank you. Any from the defense? Challenges for cause?
None, Your Honor.
Okay, does the prosecution have any preemptory?
No, Your Honor.
Are you're satisfied with the panel as it is?
The people are satisfied, Your Honor.
Okay. Defense,
Defense is satisfied.
counsel approach. Okay, ladies and gentlemen of the jury, we do have a impanelment. You 7 will be impaneled to serve on this jury. The remaining of you, I apologize that you did not get an opportunity today, but you're in luck. I have a jury trial tomorrow, and I don't know if any other judges have a jury trial tomorrow, so maybe your lucky day then. But we appreciate you appearing today and being willing to serve in this capacity. The remaining of you are free to be excused from your service at this point. And I am going to go over another set of instructions.
Oh, good, there are phones. Sorry.
Take your time. Okay, ladies and gentlemen of the jury, if you want to turn your attention to the screen again, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Please rise. Raise your right hand. Do each of you solemnly swear or affirm in the action now before the court that you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court? If you do, please say I do.
I do.
Thank you. You can be seated. You will get a written copy of the instructions that I'm going to read to you, but you won't get them until it's time to deliberate. You will be able to refer to them at the end of the trial while in your deliberations. I will now explain some of the legal principles you will need to know and the procedure we will follow in this trial. First, let's review the elements of the charge. The defendant is charged with assault and battery. To prove this charge, the prosecution must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery on a Nathan Harris and or on a Tianta Kennebrew. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Nathan Harris and or Tianta Kennebbrew's will. It does not matter whether the touching caused an injury. Second, that the defendant intended either to commit a battery upon Nathan Harris and or on Tiante Kennebrew, or to make Nathan Harris and or Tiante Kennebrew reasonably fear an immediate battery. The definition of force and violence, as used in these instructions, force and violence means any use of physical force against another person as to harm or embarrass him or her. The definition of a touching, a battery. For a battery to occur, the touching must have been intended by the defendant, that is, not accidental, and it must have been against Mr. Harris or Ms. Kennenbrew's will. It does not matter whether the touching caused an injury. An assault does not have to cause an actual injury. However, if there was an injury, you may consider the injury with the other evidence in determining whether there was an assault. Time and place. The prosecutor must prove beyond a reasonable doubt that the crime occurred on April 13th, 2023 within the city of Lansing in Ingham County. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyers does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. The prosecutor presents his evidence next. The prosecutor may call witnesses to testify and may show the exhibits like documents or objects. The defendant's lawyers has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyers will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you on the law that applies in this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of this case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice. you may have based on a witness's race, national origin, or ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, or suggestions or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses' questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to my court officer. He will give it to me. Do not show your questions to the other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or another are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Please pay no attention to those interruptions. You must not discuss this case with anyone, including your family or friends. You must not even discuss it with other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to the case. This means that you may not speak to these individuals even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you are not allowed to discuss this case. If they continue, leave, report the incident to my court staff as soon as you return to the court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Again, under the law, the evidence that you must consider must meet certain standards. Witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. So these restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, internet, or on social media platforms. You must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigations or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about this case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you must not post any information about this case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to my court staff. You may take notes during the trial if you wish, but you, of course, do not have to. If you do take notes, you should be careful that the notes do not distract you from paying attention to all of the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your service as a juror concludes, your notes will be collected and destroyed. You can see we have chosen a jury of 7. After you have heard all of the evidence and given my final instructions, we will draw a name to decide which one of you will be dismissed to form a jury of 6. So in other words, one of you is actually serving as an alternate juror. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. After my instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your conclusions about this case individually, but you should do so after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. Okay, at this time, it's 12:14, so I need to give you all a break for lunch. I'm gonna give you 45 minutes. You should be back at 1 o'clock. There's a jury room here that you all can store your things in. If you intend to go and get some food and bring it back, you can eat it in there. There's a bathroom in there designated for you all. We're gonna give you each a juror sticker so that you are identified in the building as a juror. Please remember the instruction that you were given that you're not to speak with any of the witnesses, the attorneys or the defendant or anyone connected to this case. And because, again, you do not know all of the witnesses, you have to be careful who you're speaking to because you may inadvertently speak to someone who's connected to the case. And we'll be back here at 1 o'clock. All rise for the jury. You may be excused. Okay. Any additional matters before we recess for lunch?
No, Your Honor.
Okay, we'll be back here at 1 o'clock. Thank you.
Your Honor.